Welcome, everybody, to Behind the Title. This is the official podcast of Trilogy and Baldacci Real Estate Closing Services. I am one of your co-hosts, Bobbie Grenier. I do not have my co-host, Jessica, with me today, but I do have Shannon Esty, who is one of our title attorneys here with Trilogy and Baldacci. Say hi, Shannon, and introduce yourself.
Hello, I'm Shannon Esty. I am a real estate attorney. I just joined Trilogy and Baldacci last year. I have 16 years of experience practicing in real estate, working in private practice for title companies, as well as with underwriting. I worked as an underwriting attorney for one of the larger title insurance companies here in Maine before joining Trilogy.
Today, we're talking about transfer on death deeds in Maine. So let's start it really simple. What is a transfer on death deed?
There was a whole overhaul in Maine, the probate code in 2019. And as part of that, Maine's legislature adopted the Uniform Transfer on Death Deed Act. A transfer on death deed is what it sounds like. It's a deed where the owner of a property grants to someone who's a beneficiary the property, but the transfer does not happen until that transferor's death. So it's a recorded deed where the person says, when I die, the property immediately transfers to this person or persons.
Why were transfer on death deeds even created? Were they trying to solve some type of problem, or what was the motivation behind the state of Maine doing that?
There are other states around the country that have the Uniform Transfer on Death Deed Act. Legislators wanted to adopt it in order to reduce legal fees. It's an estate planning tool for homeowners, and maybe their only asset is their real estate. And it was a way to try to make estate planning more accessible to people without having to hire an attorney or pay a lot of attorney's fees to have a whole estate planning package or costs associated with estate planning that one might normally think it might be a barrier to someone actually doing these things. And the goal is a transfer on death deed is something that would be outside of probate in Maine. And so it's something that homeowners would like, or it's ideal for homeowners and their families because it means they don't have to go and open a probate case when someone passes away. They can do it all outside of probate. That was initially the idea, was you don't have to hire you don't have to go to an attorney. You will pay less in legal fees. But ironically now it's currently used most often by attorneys as another estate planning tool. And so you're still dealing with people going to attorneys and they are paying legal fees to prepare these documents, but it's just another tool in your toolkit for estate planning for people who own real estate.
The presumption, I think, when somebody does a TODD, transfer on death deed, is that they're going to live in that property until they pass away. But life happens and people want to sell their property. What does a transfer on death deed do when we're looking at the title search when somebody has listed their home?
You might see a transfer on death deed as one document among a bunch of other documents in an entire estate planning package. You might have a power of attorney, a durable power of attorney. You might have a medical power of attorney. You might have a will. And then you might also have done a transfer on death deed for the specific real estate that well, I want it to go to this person when I die. And so instead of having to specify that in your will, you do a transfer on death deed so that they don't even have to have that property in the probate case. It's separate and it's automatically happens when you pass away. But like you said, things happen. And so estate planning is in the moment. And so life happens even after you've done all of your estate planning. And that's like wills get changed. That's what happens. Your assets might change. So your will might say that this goes to someone when I die, but you might not own that property at the point where you die. And it doesn't matter when it's in your will because it's what you own at the point where you've passed away. But for a transfer on death deed, you've already put in a deed that when you pass away, this property goes to this beneficiary. But what if you need to sell? Or what if you want to refinance your mortgage? I guess I would look at it in a couple of different scenarios. The first scenario is, let's say you need to refinance or mortgage your property, but you've already recorded a transfer on death deed in the registry of deeds. In that case, you might be required to revoke that transfer on death deed, depending on what title insurance underwriting requirements we're dealing with. In some cases, it might be okay. In some cases, you might have to revoke it and then re-record a new one. You might want to sell your property that has a recorded transfer on death deed, but you're still alive and you want to sell it at that point. So usually you'd need to revoke that transfer on death deed, or in your deed to your new buyer, include a statement of some kind saying that you're revoking the transfer on death deed as part of the transfer.
To simplify it, if somebody grants a transfer on death deed, so say I grant a transfer on death deed that upon my death, my daughter, I give a deed to my daughter. And so when I pass away, title to that property will automatically go to her. She does not have to go through the probate court and through the whole probate process. So if something happens that I want to sell the property or refinance, do I need my daughter to sign? Do I need the person that I granted the deed to? Do they have any rights as far as not giving the deed back to me, or maybe having some type of right to sell the property themselves, or they have no title at that point? Is that correct?
That's correct. This is all conditional and nothing happens until you've passed away. And so if you decide you need to do something with the property before you've passed away, even if there's a recorded transfer on death deed in the registry of deeds and you've completed it, nothing transfers until your death. And so it's still completely your property, and any beneficiary named in the transfer and death deed does not have any vested interest whatsoever in the property yet.
I think that's an important point to make, too, because a lot of people think that they've given this deed knowing that nothing happens with it. There's no transfer of title until the event where the grantor does pass away. And I think that when this all came at first, that was sort of my confusion, like, okay, what are we doing with the beneficiary? And the answer is nothing, really, if we're doing title for a refinance or a mortgage or sale.
Yes. And I think that especially if you're an agent looking at a potential listing with a new client and you see a transfer on death deed, that's certainly not a barrier to you doing business with the seller, because it will be very clear that it's a transfer on death deed right at the very beginning of the title. The title will not be warranty deed or quitclaim deed. It will be transfer on death deed. So it's different from other estate planning tools with deeds where, like, you might see a parents granting to themselves and their child as joint tenants, so that when they pass away, it automatically goes to the child. The child then already immediately gets an interest in that case. In this case, it's different because the transfer of interest doesn't happen until the person has passed away. It's important to see that maybe there might be a couple of extra steps when you're selling in terms of revoking it if you're still alive, but it doesn't take effect until after you've passed away.
So to your point earlier, part of the motivation of enacting the transfer on death deed in Maine was to help people not have to incur the legal fees and sometimes the time period of going through probate. So with that in mind, I'm sure a lot of people are going online and pulling templates and forms and that sort of thing. What would you caution people about doing that?
Yeah, so I mean, one of the unique things about transfer on death deed statute in Maine is that there is a transfer on death deed form written right into the statute. And so you may see people, and we've seen this already, printing out just the statute and completing it and recording that. And sometimes that works. It usually doesn't, mostly because it's still a deed and the deed still has to comply with the basic requirements for the construction of a deed. It has to have a grantor and a grantee. It has to have the language. If you're printing the form off, you've got all the language, but it also has to be notarized. I would caution people mostly because there are a lot of different circumstances in estate planning that you have to consider. And sometimes a transfer on death deed is not the ideal type of document or instrument that you want to rely on. And that's why in a perfect world, the idea was to reduce legal fees and allow for you to not have to go to an attorney for everything. But oftentimes, estate planning attorneys have a lot more information about what might be the best option for you. And so this is helpful. And we'll talk about that because selling property as a beneficiary of a transfer on death deed is a lot more difficult than I think the legislature anticipated or the general public anticipated it would be because of some of the hoops that have to be jumped through that weren't necessarily considered and that we're still kind of working through. And it's already been 6 or 7 years since the statute passed, and we're still working through some of these problems now in the real estate industry here in Maine.
I think it's a case sometimes different areas of the law bump up against each other. In this case, estate planning and probate are bumping up against title standards and real estate law. And I think that we're getting better to work it out. But at first, it was sort of like, okay, how are we going to deal with this because they're out there?
Yeah, and I mean, it seemed like on a super high surface level, it seems like a great option, and it is. It's a really good option for some people, but in very specific circumstances. But a lot of times, there are other scenarios that are more difficult. And I mean, if there are a lot of liens, if there are a lot of potential creditors, if there are interests between the parties that are possibly compromised or might have an appearance of undue influence or compromise, then it might unwind things and make the transaction a little bit more risky.
Let's talk about powers of attorney and transfer on death deeds. What if somebody holds a power of attorney and as POA, they sign a transfer on death deed on behalf of mom and they grant it to themselves? What would happen then?
So this is like our biggest problem at this point that we're dealing with. The only way that works is if the mom's power of attorney very specifically includes the authority to gift property, gift to the agent, and also specifically by way of a transfer on death deed. And so there's very specific language. It's evolving. I can tell you the Maine real estate section, title and section of the Bar Association, we're working on a title standard to address this because it's not clear. But essentially, in the same way that a transfer on death deed grants to someone, so you have to have the authority to act. A power of attorney is a very specific fiduciary relationship between a principal and an agent. And as an agent, or sometimes we call it an attorney in fact, if you hold power of attorney, you are bound by fiduciary obligations to whoever you are acting on behalf. So whether it's mom or dad, you're acting in their best interest when you're signing as their power of attorney on any document or doing any kind of actions that you take as their power of attorney. And so if you sign a transfer on death deed granting yourself the property when your principal or who you are acting as power of attorney for passes away, you're gifting the property to yourself outside of probate and outside of the normal checks and balances that might have happened in probate regarding this kind of a transaction. It's the same kind of a scenario where we haven't talked about the Uniform Improvident Transfer Act, but there is something in Maine called the Uniform Improvident Transfers Act. And this is a presumption that if a grantor is over the age of 65 and there is a conveyance of property for less than fair market value, that there's a presumption that that person is being unduly influenced in some way. And in order to rebut that presumption, the seller get their own counsel, and an affidavit is usually signed saying that that person acknowledges that they are transferring the property for less than fair market value and understanding the risk, but they get separate independent counsel for that. That same thing would be triggered if you had a power of attorney signing a deed on behalf of mom to themselves, even if it was just a straight deed. The presumption of undue influence would be there if they didn't have the authority for this gifting. And so the transfer on death deed scenario is kind of like a loophole that we've now realized is a potential loophole and therefore problematic, because the authority has to be there for a power of attorney, and the Improvident Transfers Act would potentially also trigger as well. It's not as clear cut whether or not the Improvident Transfers Act would actually trigger, though, because the transfer doesn't happen until after the person has passed away. And so then you kind of get in this weird cyclical chicken before the egg, and then you're just, which one is triggered? And so it's caused a lot of questions, and that's why the bar is dealing with putting together a title standard on the issue, because it's not clear. Generally, it's something that if you think a transfer on death deed is something that will be part of your overall estate planning package, it's something you need to communicate to your attorney who's also preparing your power of attorney, because the power of attorney has to contemplate and allow for that type of gifting if it's going to work.
And just to clarify, the Improvident Transfer Act, and actually a lot of the things that we're talking about here, are to protect from financial elder abuse, or, family members or others taking advantage of somebody that's elderly and getting them to sign documents, or having a power of attorney and allowing them to sign documents and not fully understanding what they're doing or what they're giving up.
There is a very specific provision in the Transfer on Death Deed Act that the transfer on death deed has to be recorded before the person passes away. That's another check.
Let's talk about mortgaging property with a transfer on death deed. Simply put, it can still happen, but what does the homeowner or borrower need to do in order to address the transfer on death deed that has been put in place, recorded at the Registry of Deeds, if they want to mortgage their property?
The statute on its face allows for a homeowner who has a recorded transfer on death deed to certainly do a mortgage or to sell while they're still alive. And it should not impact your ability to get a mortgage. That's not the reason why. In some instances, a title insurance underwriter might require that the transfer on death deed be revoked. In some cases, they may not require it. It also is by virtue of just signing the mortgage, they are revoking the transfer on death deed. But usually, coming from someone who worked as an underwriter, underwriters want things spelled out a little bit more clearly. And so they may require a revocation get recorded just to make the record extremely clear of what all the parties' intentions are. And so sometimes one might say, oh, well, you could kind of get into an argument thinking, but it's not required. And you keep looking at the statute and saying, but it's not required. But sometimes it's more about making sure that the record is very clear in the Registry of Deeds as to what all the parties' intentions are. And so maybe it doesn't have to, in its purest sense, be revoked, but it still might be a requirement.
So what I'm hearing is that if you've granted a transfer on death deed, it's been recorded, it's in place, you want to do a mortgage, a refinance, you're not selling, but you're mortgaging your property, there's nothing to stop you from doing the mortgage. However, even though statute says that this is okay, it's a great moment to remind people that although title standards have to follow law and statutes, they can have guidelines above and beyond what the Maine statute says.
And also think about, it takes time to get to a closing where you sign documents, during which time someone might pass away. And then the transfer on death deed, if it hasn't been revoked, is triggered. Obviously, if you're mortgaging, you're not going to be signing mortgage documents, and so the entire transaction doesn't happen anyway. But if you're selling a property while there's a transfer on death deed and you're still alive, you can still sell your property, but most likely title companies will require that you revoke that prior to even scheduling a closing. And the reason is, if you walk out of your closing after signing a deed that also revokes a transfer on death deed, and what if, heaven forbid, you are hit by a bus before that deed gets recorded, your transfer on death deed triggers before the deed to your new buyers. And so it's you will find, and it may seem like an additional hoop that title companies are forcing people to go through to revoke a transfer on death deed when they're trying to sell property, but it's mostly to be sure, okay, there is no other outstanding possible risk or interest that might trigger during this contract period, or even after the closings happened before we've recorded the deed.
This is a great time to remind people that it's not just having a revocation of the transfer on death deed signed. It needs to be put on record at the Registry of Deeds for all the reasons that you just talked about, that should a seller pass away and the deed to the new owner isn't put on record and the transfer on death deed is still out there, the timing of the documents being recorded at the Registry of Deeds matters.
What happens is we just think of the worst case scenario, and that's what underwriters are going to think of in terms of worst case scenario. But this is why the job of the title agent and settlement agent is to make sure that all of these risks, possible risks, are addressed.
I say this all the time, that I think people forget the insurance piece when we say title insurance. And insurance, whether it be title insurance or homeowner's insurance, whatever insurance you're getting, it's all about assessing risk and loss. Title insurance is no different, and that's how they have to look at it when it comes to the transfer on death deeds. So if you are, let's talk about the beneficiary side. If you're a beneficiary on a transfer on death deed, the grantor of the deed does pass away, you automatically own the property, or is there anything additional that you need to do to have title fully vested in you?
Yes. So when the grantor of a transfer on death deed passes away, the transfer is triggered. The way to establish that ownership is to record a notice of death in the Registry of Deeds. There's a statutory form written right into the law. It's a requirement, and that vests the title to you as of the date of death. So even if the notice of recording is later, the title is vested to you as beneficiary as of the date of death once that gets recorded. You can sell as a beneficiary. There are just a lot of hidden challenges, especially because it's a new process.
What are some of the challenges?
If you're selling as a beneficiary of a TODD, I would say right up front, and especially if you are listing a property, if your client is the beneficiary of a transfer on death deed, you're going to keep in your mind, when did the prior owner die, and has it been a year? And so if it has been less than a year, you're going to be faced with certain challenges. If it's been more than a year, you'll have less of those challenges to deal with. There is a really big misconception that if you have a transfer on death deed, you can avoid probate completely. That is not the case. That's not always true. And that's when this timing comes into play. So, and insurability, like we said, we talked about title insurance, and this is kind of where there are a lot of questions. And even 6 or 7 years after this statute being enacted, we're still dealing with these questions. We don't have all the answers because it's a relatively new. In the world of real estate and the law, 7 years is not a long period of time. That's a relatively, quote, new scenario.
So if a real estate agent walked away from this podcast, what's the last thing that you would want to tell them, the last thing that you would want them to think about when their client either has granted a transfer on death deed, so it's out there, or if their selling client gained the property as a beneficiary of a transfer on death deed?
Yeah. So if their client is the person, the transferor, and they have obviously not passed away at that point, then they shouldn't have any issues. They shouldn't have any issues selling. Most title companies in Maine are now used to seeing transfer on death deeds. They should not be a barrier or a delay whatsoever in terms of getting to closing and selling, just as another step. And if your client, as the seller, is a beneficiary from a TODD, my biggest takeaway is, when did that person pass away? That is going to influence the type of buyers and how quickly you can move and if you can close. If the goal of your beneficiary is to move it as quickly as possible and to sell the property as quickly as possible, the best bet, I would say, would be to look for a cash buyer. It's more likely to take on some of these risks rather than a finance transaction where you'll have a lender involved who will not necessarily want all of the additional risk, or might also end up requiring that a seller open a probate case And so if the goal is to have it sold quickly, you don't want to have to open a probate case. If the goal is to try to get the highest purchase price, that's different. If you have a seller who's willing to do the steps, and maybe we do have to open a probate case and that takes a little longer, but your purchase price is higher, that's another option too.
It's not as simple as it appears on its face with a TODD that one person passes away, the family home automatically goes to the beneficiary, and then they can live there, they can sell it, they can do what they want. It's a little more complicated than that.
Definitely. It's not always that you're dealing with a parent giving to their one and only child. There are a lot of different working move-in parts with families, and anytime you're working on any of these kind of transactions, knowing as an agent who you're working with and who's on speaking terms with who, can you even find this person, is going to be a really important piece. And the other piece would be, it would be important to know if that person lived in Maine or not. Did they die out of state? Because if they died outside of the state of Maine, then that triggers a whole other set of circumstances that you have to accomplish.
We have covered a lot, and I'm not going to lie. Now I have a few more questions than I even had before we got started. So I think we need to do a probate episode. I think that would be awesome and really helpful to people. Well, thank you, my friend. I appreciate you coming on again and talking with me.
Thank you for having me.
We hope you've enjoyed this episode of Behind the Title, the official podcast of Trilogy and Baldacci Real Estate Closing Services with your hosts, Bobbie Grenier and Jessica Mung. Remember, this podcast is for informational, educational, and entertainment purposes only and not intended as legal advice. Please remember to follow and rate the show and share this episode with a friend.